calling to order the special board meeting of Paris Union High School District at 4:07 PM. Okay. At this time, item 3.1, the Pledge of Allegiance. If I can have you all stand, please. Ready? Begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, invitation to address the Board of Trustees, agendized and non-agendized items. Are there any takers? We have none. Item 5.1, general functions, governance update.
Yes, we had spoke previously about wanting to have a refresher on some of our governance things that were in our handbook, what we put together a couple years ago. So I've asked Mark Thompson from AALRR. I couldn't remember all the names, but I got the acronym right. He's one of the lawyers over there and one of the partners, and he's going to lead us through the process. So I'm going to turn it over to Mark right now. We're going to move down to the tables at this time, so it's easier for us to see.
Some of you others that I've met before. My name is Mark Thompson. I'm with the firm Atkinson Anderson. I want to be real respectful of your time tonight. So I have about 20 slides. I'm not going to read every word on the slides because a lot of it comes directly out of your own governance handbook and out of your own board bylaws. So what I'm going to do is kind of organize it in a discussion on what I find to be the most effective and valuable parts of your own procedures and policies and how you might think about implementing those. You may be doing already, in which case if I'm reinforcing you, I may should be some time for that. I don't want to spend too much time. But I'd like to go kind of through my view and my approvals and my constructive criticisms perhaps of your board bylaws, your governance procedures. And perhaps I can learn a few things, perhaps you can learn a few things tonight. And like I said, we can have some discussion at the end if you like. One of my areas of expertise is, I should be talking here, I'm sorry. One of my areas of expertise is the Brown Act. And so we can go through any concerns that you have regarding the Brown Act. You know, we live with it. We live in an environment of open government. Our constituents deserve that. That's what the legislature have decided. So what we do is we find ways to work within those confines of the Brown Act, even though it seems inconvenient at times. And then we apply that to your environment as local agency representatives, governing members, to allow you to get your work done, even though you only get to meet once or twice a month. It's a real balancing act. It's a real challenge to follow your guidelines, follow your governance rules, follow your bylaws, follow the Brown Act, follow everything else, and still get all the important work done that you need to get done once or twice a month. So we put all that in this framework, and I think you've got some real good stuff in your governance guidelines that allow you to do that. But I'm here to help kind of sort through any of it that's a little too complex at times. So starting right away, the way I view this is how to apply these rules and still be a highly effective board. And some of you have a lot of experience with that. Some of you are newer to the process. But there are a lot of things we see that are common to a lot of effective governing boards, and they just so happen to dictate what we find in the CSBA model board bylaws, so that everybody tends to do things more or less the same way, just adding some local flavor based upon what's important to your constituents and your stakeholders in your district. So we start here with the Paris Union High School District Governance Handbook. You've got a fairly concise but also thorough handbook that talks about how to implement your board bylaws and implement the Brown Act into the way this body likes to do business. Thank you. And so, you know, Superintendent Bennett sent me that handbook a couple of weeks ago. I went through it and found it to be actually refreshingly concise, but also very effective and thorough. So most of what I'm talking about is going to be built right around what I found in your own governance handbook. And it starts with 3 areas of focus for effective governance in Paris Union that perhaps some other school districts might want to model as well. The 3 areas are governing as a unified team, mutual support for roles and responsibilities, and creating and sustaining a positive culture. And so I highlighted the key words that I saw in there. Unified team. You know, the rules allow for individual thought, individual opinions, individual approaches to what each board member and their constituents find important. But when you bring that all together and the board takes action and, you know, by a majority vote and establishes the vision and the guidance and the, you know, the path for the school district, it needs to be as a unified team. And that's for a couple of different reasons. That allows the board to, even after expressing differences of opinion, come together and move forward with the governance of the school district in a way that's required by majority vote. It also projects an appearance and projects an environment for your stakeholders, for your constituents, that they see there's an effective governance project moving forward, a process moving forward as a unified team once everybody's had a chance to express their individual opinions, put their individual inputs into the equation, and then come out with a majority decision on path forward and goals and so forth. So it's pretty important to project yourselves as a unified team with a unified voice once the decisions are finally made, after the debate is over. And that goes along with the shared vision. The board acts as a body, and even though the body has several parts, effective governance come when the parts of the body come together and all work in the same direction down the same path. And so the shared vision is also part of that important piece that shows your constituents that we've got effective governance happening in this district, and that decisions are being made and then followed through on based upon the stated, you know, mission and vision of the school district. So the second of the three areas is mutual support for roles and responsibilities. And the mutual support comes from each individual board member subscribing to and supporting the governance handbook, the protocols, the bylaws, everything that's been adopted in this district, and perhaps amended as, from time to time as changes are deemed appropriate by the majority, and supporting and subscribing to those rules so that the constituents and the stakeholders can see that we've got a system in place that's working. Everybody's kind of agreed upon the rules and following the rules. And that goes to the roles and responsibilities. You have a heavy burden of making the right decisions for the children in the district and for the community. And you accomplish that by putting the structure in place where you've hired a qualified superintendent to supervise the department heads who are put in place to manage human resources, student services, special education, business services, facilities, all those moving parts that go to keeping the district afloat. And so when board members are respecting and paying attention to their highest level role and responsibility in that process, all parts are working at the same time. That's built right into your governance handbook. And then finally, creating and sustaining a positive governance leadership culture. The culture is what is seen by your constituents. It's seen by the labor unions. It's viewed by the parents and the students and so forth. And so saying that we want a positive culture almost goes without saying, right? But it's sometimes difficult when very important decisions, high-level decisions are being made by 5 separate individuals with 5 separate potential views on how to move forward, that once decisions are made, they're presented and supported in a positive culture. And when your constituents see that, and when your stakeholders, the students and the parents see that, you've got a better learning environment, an effective, efficient, and more beneficial learning environment. And that's, from my perspective, after reading through this, that's what this is all about. That's why it's written that way. So I'm going to look at some of the specifics from your governance handbook and from your board bylaws, starting with the roles and responsibilities for board members. And it sounds pretty daunting to say that my responsibility is to run a school district. It's like running a city. You've got a lot of people in your city that need your services in a lot of whole different ways. But the board's responsibility really is to come together as a body of 5 and make decisions that guide and that set goals and set the vision for long-term policies, practices, and sometimes changes. And so one of the principles that we find in your governance handbook at page 4 is that all board members are equal. That's a true statement. Now, sometimes board members have slightly different responsibilities, but board members' power is equal. You're 1/5 of a 5-member body that rules and governs by majority vote, and everybody has an equal say. But the authority rests with the board as a whole, which means the board majority, as that may change from time to time, and not with individual members. So individual members will have their own approaches to curriculum or discipline or outreach to students, and then those discussions occur, but the action is taken by the board as a whole and not by individual members. So that's really the first principle, and that's basic, and I think everybody understands and appreciates that. The board sets the policies of the district. They are your board policies, and they more or less cover, at least at a high level, everything that's happening in your district. Now, you're going to have to vote on important guidance items, directing the path of the district each year, or sometimes more frequently than that. I mean, the LCAP comes to mind. That's a critically important roadmap for the district that moves forward. And you'll have to do that every year. That's not built into a policy. But for the most part, the rules and regulations and the governance standards in this district are set forth in your board policies and in your board bylaws. Most of those policies have a function that directs the superintendent or the appropriate staff to actually turn the nuts and the bolts, run the day-to-day operations of the district. And so the superintendent's job is to implement your policy implement your vision and your guidance and your directives. And he does that through delegation of authority to the appropriate department heads, so that we've got people handling HR and we've got people handling business services and IT and all the various functions within their own expertise under the supervision of the of the superintendent, which is under the guidance and direction of the board, and that's the top-down structure that you're all familiar with. Yes, sir.
You used the word that I found really well, expertise. What would be assumed to be the expertise of a board member?
Well, the expertise of a board member, interestingly, there's a part of your governance document. No, it's one of your board bylaws that talks about the qualifications for board members. I didn't incorporate that into the presentation because it's more about, what's the background of a board member that's most beneficial. I can take a minute and go through that with you.
So the reason I bring it up is because sometimes people expect us to be experts on personnel, but it helps to what, we could be Joe Blow voted in by the community. We might not have that expertise. So I just kind of appreciate a real quick description of what you would consider to be necessary.
Well, let me tell you what I think the correct answer is, and then we can have some discussion on that. Board members are elected by your constituents because of your values and your positions on curriculum or new approaches to student discipline and how I'm going to improve attendance and those kinds of things at a real high level for the school district. Board members are not charged with, and quite frankly, your bylaws would teach against having board members get intimately involved in HR functions or in property negotiations or labor negotiations or procuring equipment for information services. That's not what board members are elected for. You're elected to bring your vision as human beings and as leaders, sometimes parents, community members, to the table to say, I represent some of the values of the Paris Union area, and I'm bringing that to the table as one of 5 people to put together a governance team to make high-level decisions on the direction of the district. Yeah, you get to hire the superintendent. That's kind of a personnel function, but it's pretty unique. The superintendent is almost an extension of the board. Perhaps the right arm of the board is actually an accurate depiction. And so the board gets to determine who is the right CEO for this organization. So that's kind of a personnel function. But below that, the superintendent is ultimately charged with making recommendations for the cabinet based on this person's expertise in human resources and that person's expertise in the business services functions. And then, of course, those decisions are typically approved by the board after being promoted by the superintendent. But beyond that, all the HR functions then fall to the administration. All the business functions fall to the administrators.
Led to the perfect ending there. I was on another board and there was some miscommunication about they wanted to have the board members sit in on hiring panels.
Mhm.
A couple times we sat in and observed negotiations. I'm not so sure that that's something that we're supposed to be doing.
That's a choice. There's nothing that says a board member can't sit down in negotiations. I'll be perfectly honest with you, and I'll say I would advise against it because that puts that board member in a position of pressure by the associations, and they'll take advantage of it. It's right in their playbooks, unfortunately. And please forgive me if I sound a little bit jaded. I'm on one side of the table and not the other in negotiations, so I'm going to sound like I'm pro-district and perhaps anti-union, but that's my job, forgive me. But the answer to the question is, because the governance team is 5 members with equal shares, and they move by majority action, majority vote, it kind of unbalances the playing field if we put one board member in with negotiations. I had a district that would rotate. Every single board member would sit at the bargaining table. That made me uncomfortable because that made the bargaining team unstable. Board members have important input for us,
but we like to get our input from the board as a whole, and we're allowed to do that, and it's beneficial. The legislature has decided it's beneficial that the board can do that in private, establish its bargaining goals, because like it or not, it's adversarial. We've got the budget, they want the money, we have to negotiate, and we have to keep those two teams separate. It's all for the good of the employees, we know that, but we can't just have the employees hearing district bargaining strategy, because there's a lot more to the district's budget than the 92% that goes to salaries and benefits. The point being, the board should receive the same information at the same time. And if you have one board member at the bargaining table, that person might certainly report back to the other board members when you get to the next closed session, but it's kind of different from being there. So, and it creates an instability in the bargaining team. So that's one example where I would typically recommend that individual board members not get involved, because the other side of that is, in my past experience, not necessarily in this district, the bargaining units will absolutely do their best to take advantage of the divide and conquer opportunity. That was a lot of words. I hope I got your question. Okay. Yes, sir.
I think you addressed the bargaining participation and not interviews. So summarizing, just for bargaining part A and interviews part 2.
Sure.
So negotiations, you are not advising to them, but that doesn't mean that it's complete.
That's correct.
So the bottom line is that is the board, the one who makes that decision, taking into consideration the advice and the input in this case the board, correct?
Yeah, and you should bounce that off of your administration. They may know the labor union and the environment in bargaining a little better than you do, but certainly there's no rule that prohibits it.
So legally, we're not prohibited.
With one exception, you can't have more than a quorum. You can't have a quorum or a majority. You can't have 3 members at the same table unless you put it on an agenda.
Exactly. Okay. Can you follow up in part 2?
So interviews, certainly the board would interview superintendent candidates. I've seen boards that like to get involved at least a little bit in interviewing, I think it would be fairly common to interview at the cabinet level. These are important people that you're going to be entrusting with your budget and with your students and with your employees. But when it gets below that, it becomes inefficient probably to try and get board members involved in every interview of every principal, every teacher, every custodian, because you have so little time. I guess the next question is, well, can we do that as an individual board member outside of a board meeting? There's no rule against that. My caution on that is you've got labor associations that take a great deal of interest in the hiring process. And beyond the labor associations, when you have individual employees, for example, that challenge hiring practices, or you have the EEOC or the DFEH that's coming in and looking at your hiring practices. If your practices are not consistent from one hire to the next, you're at a disadvantage in proving that you didn't discriminate, for example. So the district probably has protocols, and I'm not familiar with this, but most districts have protocols for how to establish a interview panel. Sometimes that even involves the labor associations. If that is a consistent practice that would involve a board member, then I would be not as uncomfortable because it would be defensible if you're being looked at in a discrimination claim for somebody that didn't get hired. But that's not something that I see very often. Board members are setting policy rather than getting into the day-to-day operations of the school district. That's why you hire everybody that you hire in the administration.
I think I've heard that from that's why we hire someone to do it, but it's kind of strange that it's my understanding that in several districts, probably when was a nation, to do that. It is a personal experience. I can tell you when I worked at Alway at the time, I went to, I was applying for a high school interview. Middle school principal, went to the first interview, parents were there, they were part of the process, students, union members, and the directors. Then I went with cabinet second, and they selected 3, and the one who hired me and interviewed the 3 of us was the board technician.
Interesting.
5 of them.
And that was at the principal level? Okay, so
I'm
we're,
not saying that that is something that we don't to do, right? But once again, if we say the same conclusion, the gist of the summary of everything is the same for negotiating, that the board analyzes that and they make a decision. If somebody wants to do it, it's not going to be as a responsibility that any collective entity, they say, no, you are going to be here, right? Be part of the review. But if somebody wants to participate, there is no legal impediment.
there's not, as long as you follow the Brown Act requirement that we talked about.
Follow the Brown Act in the protocol for the interview process.
My recommendation is to try to keep the board's governance at the governance level. So, I've seen districts that do bring in, once a candidate is narrowed down and selected and proposed. And I'd actually look at your board bylaws too, because it might actually specify, or sometimes your administrator contracts specify that this person has a responsibility to bring a recommendation to the board, perhaps the superintendent. And the board can either approve or not approve that recommended hire, and then the superintendent would go back to the drawing board and bring another person. I don't see boards get involved in the actual hiring panel process at the early stages. I've seen boards get involved in the final approval of this principle. And that sounds like that's what you experienced in your district.
Yeah, and that is not common. And that's not something that I propose all the time. And it is to that, like if somebody wants to, if they get the time and the opportunity, if they would like to participate, it's not something illegal.
Yeah, I think it'd be something that would be driven by a board decision.
My board is the more things.
Our process right now, just so you know, we do it, the principal of, we do the interviews like Dr. Ross was talking about, principals of parents and students, members and stuff. They cut it down to 2 or 3 candidates, and they come to the cabinet, those 3 candidates.
Okay.
And then we narrow it down to 1, and we bring that to the board, and principals of are interviewed by the school board in closed session.
I'd say that's fairly common. Getting students and parents involved is an interesting and I think it's a forward-thinking community engagement step that's probably not quite as common. But having the board get involved in the final hiring decision, I think, is pretty common the way you described it. All right. Let's see. So this talks about the board's roles and responsibilities, setting policy, superintendent implements, and then provides direction and delegation to the department heads to actually run the district on a day-to-day basis. Instead of having the board having to do that, because you only get to meet once or twice a month for a few hours. So this is the way it looks like, top down. I mean, it's not super complicated at all. The board provides policy and direction to the superintendent. I had a board tell me once, a board member told me, the only job for the Board of Education is to hire the superintendent. I don't necessarily agree with that, but the thinking there kind of follows what's in your own governance policy. You set the vision and the guidance, and you pick the guy to lead the ship, to steer the ship, guy or gal. And I guess, of course, you'll evaluate your superintendent, as it says there and as it says in your governance documents. But it's really a high-level governance situation. You're Congress, you're not the postal worker in the post office. You are the highest level of government in this district. So you do those 2 high-level things. And in terms of, the vision and the goals, that includes the LCAP and those important high-level decisions, curriculum decisions that are made by the board. Everything else gets kicked down in most cases to the superintendent, who's the CEO of your corporation here. You're the board, he's the CEO. And he, in terms of governance decisions, he'll make recommendations to the board. That's true in every district, and it's contemplated that way in your governance handbook. But the board gets to make the decision by majority vote. The board can direct, nope, we want to look at a different direction, and the superintendent will go look in that other direction. And he'll employ the talents of his cabinet and their underlings to bring those recommendations back to the board, and the board gets to make the final decision. So he makes recommendations and receives the board's direction. He delegates and supervises the implementation of the board's direction down to the subordinates. And in most districts, and I think this is the best practice, the superintendent is the liaison between the board and the constituents. Of course, you get to speak in board meetings, and your constituents get to speak to you in the board meetings. Your stakeholders always get to speak to you in the board meetings. But typically, the board gets to meet privately with the superintendent, give direction, and then the superintendent acts as a liaison, in most cases, between the board and the community and the stakeholders. And then finally, the superintendent recommends the candidates for the cabinet, subject to board approval. And it's the cabinet that actually implements and does most of the work, right? I've got a couple people applauding, right? Maybe that's not true, but maybe it is. And it's the cabinet members and their underlings, their department heads, that actually do the day-to-day operations of the district. And so it's a huge Christmas tree with the Board of Education at the top. Yes, sir.
You mentioned something that the board is the only one who hires is the superintendent.
Well, the board actually hires everybody. The board hires and fires everybody.
That was my reaction to the question, because in every meeting from CSBA, we are told the only one who works by the board is the superintendent. He's the only one. He's the only employee of the profession, right? But from the legal perspective, and I have been sharing this question, so why is that the if everybody else works for the superintendent, why the superintendent don't hire them and is responsible for them? Because we have to approve it, right? It's a board. Why do we have to approve them? And if the only one who works for the board is the superintendent. If an employee sues the district, that lawsuit, if they work only for the superintendent, why do they sue them? If they don't work for the board?
Well, they work for the agency, and the board governs the agency. But the board hires people from the top-down perspective to actually run those things. I mean, it's a true statement, and you know that it's true because the board has to approve all the personnel reports, all the way down to substitutes, right, Kurt? So you approve the hiring, and on a sad day, you approve the dismissals and releases of every single employee in the district. The extent to which the board members get involved is different at every level. So you've got the consent calendar with the personnel report that handles probably 95% of the employees that are either coming in or going out of the district. And it's the top 5%, and in particular the superintendent, that the board really gets involved in the hiring process.
So, and we understand that. Right? So that statement that the CSBA makes, that the only one who works for the board is the superintendent, is not exactly true. Can you say that?
Um,
They're trying to get across that we're not responsible for day-to-day
Yeah,
operations.
exactly. And we can understand that. And I think what they are trying to say, don't mess with everybody else. And we understand that, right? If we see something that is not happening on the school side, we don't talk to the principal, we don't tell them, hey, this needs to be doing something like that. We come and we talk to Mr. Man.
And that's the effective governance model, correct?
If that is, and we all do this. But I was just concerned, not concerned, I was curious about that statement. How truthful was that? Because then I was saying, well, I need to do it. So they are trying to say something else, but they are creating this.
Yes, sir.
I think, to me, the way to distinguish that would be, we are directly involved in the hire of the superintendent, we are indirectly involved with everybody else.
Yeah, but you do get the final say. The board gets the final say on all the hires and all the other stuff. One important point, I think, that touches on your question is that we have to be respectful of the negotiated language in the contracts, in the labor contracts. And so the evaluation language will say specifically who gets to evaluate, and that doesn't include board members in most cases. The discipline language will say what the procedure is, and if it's a classified employee, the board will likely get involved at the correct stage, about the 5th stage. The board's not, it's not appropriate for board members to get involved at the early stages. Because you can't be involved in an investigation, then you can't be the prosecutor or the investigator and then also be the jury or the judge, if you want to put it in judicial terms.
I think that is very important. All of us will understand, I'm sure, that you are expressing that. We don't get involved in that. But, for example, if there is a question, we would like to see, there was a case or a situation several years ago, and individual board members, they would like to see a file of an employee.
Personnel files are confidential. The Board of Education owns the personnel files, but the board acts as a body. So I'm laying the foundation for my answer. If an individual board member were to ask, is it appropriate for me to look at a personnel file, I would have to say no. Because an individual board member has only those rights, all of those rights, but only those rights of any other citizen. So if John Smith walked in the door and said, I want to see Sally Jones's personnel file, we'd say, no, that's a confidential document. But if a majority of the board says, we need to do something with an employee and we're going to need to see that personnel file in the next closed session, that would be appropriate. It's basically a need-to-know basis, and the board can decide whether it needs to know or not. You'd want to work through HR on that and take guidance from HR, but legally, the board as a body can review that document. An individual board member would it would be inappropriate.
And that's what I thought. So the answer would be, can I answer this? You cannot individually, but if the board decides that will be provided to the board. You can provide to the board.
Yeah, and the other, I need to remember answering, all of my answers need to also contemplate language from your collective bargaining agreements, because some of them say anytime somebody looks at a personnel file, they have to sign for it. And I don't know if that's true in your district here.
Well, actually, one of the things that emphasize what you just said, Mark, and is actually administrative regulation 1412.6. And in that specific administrative regulation, it does specifically talk about individual board members having access to personnel files, which is and we did. Individual governing board members shall not be allowed to access personnel files but the board may request pertinent information from employees' files in cases of personnel action. Just like we've done in the past. If the board as a whole said, hey, we'd like that information about to know about it, then that's the perfect time to talk about it in closed session. And that information to you.
And it would be my advice to segregate the information. I think what Kirk's getting at is there's some stuff in personnel files that is confidential and serves no purpose for the board to review. Social security numbers, driver's licenses. But there's a lot that's in there that would be relevant to the board's decision-making if there was a discipline case. So it's probably more about looking at specific documents rather than perusing an entire personnel file. All right, so let me get to the next slide here. The governance roles, so this is from Board Bylaw 9000. It dictates what the role of the board is. And it says right in there, the board shall work with the superintendent. So there's your cooperative, kind of right arm kind of situation to fulfill its major responsibilities, which includes setting the direction of the district. So that's, dealing with the stakeholders and so forth. And adopt your decisions that pertain to student learning and achievement. But then also establishing an effective and efficient organizational structure for the district. And so there's some specific guidelines in your board bylaw that talk about what the primary responsibilities for the board are. And they include hiring the superintendent, and then setting his guidelines for his hiring of other personnel or his bringing to you of candidates for other positions. We're going to get to evaluation of the superintendent as well. You don't typically, as a board member or as a board, get to evaluate teachers or evaluate principals. You do evaluate the superintendent because that's your right arm. That's your person that's going to run your organization. You hire them, you evaluate them. You oversee the development and adoption of the board policies and the board bylaws as they may change from time to time. You establish the academic expectations, curriculum, instructional materials based upon recommendations from your staff and based upon each board member's individual preferences and desires for the direction of the district. Perhaps most importantly, I guess it's all very important, but establishing budget priorities. This is the most complicated and difficult part of your whole process is taking those scarce dollars and putting them where they need to go to achieve your vision and your goals as a board. Approving facilities, setting parameters for labor negotiations. So here's where it comes to play. Your staff doesn't decide what labor negotiations directions the district needs to take. That comes from the board. They get parameters from the board, what's good, what's working, what needs to change, how much can we afford to increase the employees' compensation or benefits. All of those directives come from the board. And then your bargaining team, your designated bargaining team, takes that back to the table and tries to make it happen with the limited resources that they have. And then they come back to you with a proposal for, here, it looks like we may have a deal. Is this sufficient or is it satisfactory to the board? And the board gets the final say on whether that gets ratified or not. Question?
Going back to evaluations, when we're putting teachers up for non-reelect, we hear about the evaluations of the teachers, and based on that, we what about the cabinet? The superintendent evaluates the cabinet, but we don't see those evaluations. So we're asked to approve their contract, but we've never seen any information to base our approval.
That's an interesting question. I've never been present where, in my world, I don't get involved in the cabinet level evaluation process. I'm like, since I'm the soldier for the board, I represent the board's interests when I'm called in. Initial decisions have already been made. Initial recommendations have already been made. This one may take legal action. We're going to bring the lawyers in. So I'm kind of sitting at the board's table at that point, receiving a recommendation, based on performance of the people who are entrusted with making those evaluations. So it's an offshoot of your evaluation of the superintendent that he's doing a good job evaluating and monitoring his cabinet members. And it typically wouldn't be the board's position to evaluate their work because it all falls upon the superintendent's shoulders. But it's an interesting question. I mean, I've never seen a board get involved in the evaluation of a cabinet member. So I've got two.
I was just to say that it would seem to me that, like was mentioned earlier, is more of an indirect thing. What I'm going to be doing is evaluating the superintendent. Is he accomplished the goals that have been set out? And if they're not, is it because of things like he's not doing a proper evaluation of his subordinates? But that doesn't mean I want to be in on those. I mean, again, I think it goes beyond what we were voted in to do.
Yeah, the key to that is that the board is going to be entrusted to make final decisions as a body of 5. And so, we talk about public complaints. You're going to hear public complaints. I'm sure you already have. And those get filtered back down to the administration and they handle them. And eventually those complaints come back to the board for a decision. And that's why we don't want board members getting involved in investigating complaints, because that taints that board member and excludes them from participating in the final decision-making process. I think arguably the same is true for evaluating employees below the superintendent. There's a process for that. There are people that do that. Your job is to make sure that the superintendent's getting his work done, and part of that is that he's making sure the people below them are getting their work done. I think the way it works.
Trusting is going to be extremely difficult to fairly evaluate a superintendent if you don't trust him.
Well, certainly, and that's kind of what this is all about. The governance handbook starts with, that cooperative relationship. I think as a board, you can be confident that you'll hear about it if one of your departments is failing, one way or another, and then you'll be able to talk to your superintendent about that, and the appropriate things will happen. But typically, the board members wouldn't get involved at the department level. Yes, sir.
From what I hear from this staff, is not that he was asked to not get involved in the evaluation of cabinet members. It's simply transferred to that. That's not what I heard. I heard about looking at those evaluations. And the gist of this analysis comes to something that you just mentioned. When you are going to evaluate the superintendent, that he is doing a good job evaluating cabinet members. How are you going to be evaluating the superintendent and he's doing a good job of evaluating cabinet members if you cannot see the cabinet members? So how are we, I can understand that would be a subjective, trusting relationship. No, I trust Mr. Ben, right? And I do. And I can wholeheartedly do. But then it's not about evaluating that he's doing a good
Well, I think I do understand, and perhaps the answer lies in the fact that the person that should be involved in the evaluation is the person that actually directly supervises the employee. So the board doesn't directly supervise anybody but the superintendent, so typically you wouldn't see a board member. I would perhaps argue, and I'll think about this and maybe change my mind, but for right now, I'll argue that the board, the content of a lower administrator's evaluation is really irrelevant to the board since they don't directly supervise them. You'll know if there's problems in your district, and you'll direct the superintendent to solve the problems either by replacing people or correcting people, that kind of thing. And so I think that's why we don't see it happening that way. It's because there's not much value in a person looking at an evaluation if they don't directly
So, yeah, just to summarize and close this item, what you said, that the board evaluates the superintendent on how well he evaluates somebody else, doesn't apply, we can take that out.
I didn't understand that.
You mentioned a few minutes ago, the board evaluates, is going to evaluate the superintendent on how well he's doing his job evaluating candidates.
Well, it's more about how well he's doing the job running the district.
Oh, okay, well, that's another thing, right? I just wanted to get back to that, right? Because you didn't say about running the district.
You're right.
How well he is evaluating that, right? So I just wanted to clarify.
No, that makes sense. That's a good question. I think what you've done is established that I guess one little piece of your evaluation of the superintendent is his evaluation skills. But that's not really what it's about. You're hiring him not to be an evaluator. You're hiring him to run the district and fill in his cabinet with the appropriate people. So, interesting point. Yeah, you're right about that. Oh, yes. Oh, who is next?
It seems to me that it's the same situation as the personnel file. If the board wanted to look at the evaluation as a board, as a complete board, then we would be able to do that. But otherwise, there's no reason for us to be looking at the evaluations of those who are being evaluated by somebody else.
I think that's a correct statement. There may certainly be a circumstance on a case-by-case basis where it would be relevant to the board's duties to look at those kinds of documents, and ultimately the board owns all the documents. So you get to look at them if there's a reason to do so. Yes, sir.
Jose, Dr. Ross was correct. I don't want to be a part of the evaluation process. But going back to the teacher level, we get, when we get to that point, we get a lot of feedback, emails, and different information coming at us before we're able to make our decision. So we need to know the official version, which is what we represent. What is our stance?
So, and you're right, you brought me back to your original question about non-reelections at the teacher level. So when you say emails, you're saying that as a board member, you'll occasionally get emails from other teachers complaining about that teacher. Is that what you're talking about?
Or the teacher that will be let go and wants to continue working.
Yeah.
And are making their own case.
This is unfair, please do something for me.
That type of thing as well. And you know what, by experience, we can tell you that the teachers were putting a something, actually it was a counselor were putting a something. We get getting different information. 2 years ago, we asked for the documents, the documentation, and it was, unfortunately,
It was accurate.
It was accurate, the teacher was saying.
It's an interesting problem because you have, I'm going to call it an obligation, but that's your own decision, but you have a certain obligation to be available and hear from your constituents. That's part of your job that you've hopefully embraced. And your board bylaws talk about referring complaints and those kinds of issues right back to the superintendent to investigate, gather information, and then ultimately it gets presented to the board. My concern would be, if one board member were to receive an email saying, I witnessed this teacher strong-arming a child, and that information was brought to the board by one board member rather than going back through the investigatory process, I'm not confident that all the appropriate information gets to all the board members. And so that's one of the reasons your board bylaws will say if you get a complaint, it goes to the superintendent and he delegates it to the appropriate department to do an investigation. And then the same set of information and findings and recommendations come back to all 5 board members at the same time, and the playing field is level. So that's why we always recommend, when you get a complaint or a concern from a constituent or an employee or a labor association, you listen, you take the appropriate level of interest according to your own, your own assessment of the situation, and refer it and let them know, I need to refer this back to the administration. I promise we're going to look into it, and you'll get a response. But it goes back to the administration. It doesn't stay with the individual board member. And that's because, like I said before, individual board members taking those kinds of actions can taint the process if there's an actual due process procedure that we have to follow, whether it be employee discipline, student discipline, or resolution of complaints, Title IX complaints, all of the things that require due process. So those things do go back to the administration.
Your face doesn't necessarily look like you satisfactorily answered, so I just want to make.
No, because these are actual situations, these things happen. So my action usually would be to inform the board president and the superintendent. But it still leaves out the other board members that I can't inform by Brown.
Right. Outside of a meeting, that's right.
So that's the way the statement plays. So would that be correct? That's correct procedure.
All of those things should go back to the superintendent, and part of the reason for that goes back to your board bylaws and your governance manual. Individual board members are just the equivalent. They have all of and no more of the rights of any member of the public. So that would be the same as an employee going to a member of the public and saying, I saw Mr. Jones smoking a cigarette on campus, or that's not very.
So effectively, are you telling him that he should not send it to the board president, just to the superintendent, so the superintendent can then make the decisions necessary and then bring it back to the board as a whole?
That is my recommendation, because even the board president doesn't have really any authority to get involved at that point. In my school district, the Mark Thompson School District, if I had it my way, board members would refer each issue to the superintendent, and then in the Friday memo, I don't know if you do the equivalent of a Friday memo, information can be disseminated at the same time to all 5 board members, as long as they don't respond. One-way communication. And then all 5 board members have an update. We've got an issue that's arising at school site number 1. We're going to be doing an investigation. The matter will be brought back to the board when we have more facts. We'll give you an update at the appropriate time at an agendized board meeting in compliance with the Brown Act. That's safer for a lot of different reasons. It avoids the possibility of a serial meeting if somebody accidentally talks to the wrong person, and now you've got 3 board members involved in Brown Act violation that can invalidate any future action. You don't want that. It also prevents the possibility that different board members will have different levels of information, and then decisions don't get made with equity. There's one of the guidelines we're going to talk about if we get that far is that the board members are fully informed and presented the information in a way that they can pose questions, and all 5 board members can hear the same answers and get the same responses, so that decisions can be made kind of on a more equitable basis. Now, Mr. Stafford, you asked originally about non-reelections, and I think I got away from your question a couple of different times. Did we cover what you were talking about?
The point really is when we receive information, how the route where it goes from non-reelections about evaluations, looking at why we're asked to approve those decisions. Originally it was about cabinet level. The superintendent evaluated cabinet, if we approve their contracts, then we don't see any information. So based on approval, the superintendent.
Well, at the teacher level, you're going to get those complaints, and you probably have. When those get filtered back through the administration, and they can take appropriate action based upon the whole picture and based on the evaluations that they're privy to, rather than just the complaint of one person that comes to one board member. Ultimately, those recommendations will get back to you. We recommend non-reelection of this person for all these reasons, or we don't recommend non-reelection. you know, you were talking about back at the cabinet level. I think as we pointed out, if the board was called upon to make a employment decision based on a cabinet level person, you probably would need to see evaluations, or at least hear feedback on the person's performance through the superintendent. So that's the difference between those two scenarios. Most of the time, board members don't get involved in the details of a decision to non-reelected teacher. That's a lower level decision. We do that without cause. Have to have a reason, but you don't need to have a cause. You shouldn't have cause for termination of a probe. And that's just based usually on, more often than not, the recommendation of the principal. You know, just like you entrust decision-making to the superintendent, he entrusts decision-making at school site level to his cabinets and then cabinet members and then the principals. It's the principal that knows if the teacher's doing a good job or not, a bit more so than anybody else. Yes, sir.
You're perfectly right, and they make a recommendation. However, there are some situations, the vision in the direction of the board is to have what is right, do what is right in the benefit of everyone. And that's our commitment. By experience, we have seen some situations that we need to confirm. I mentioned that a few minutes ago, and that's why it is important for us at some time when there is some discrepancies to look at the evidence. So we can make the decision, yes, we approve this teacher not to be reelected, or we are not, or no. What's going on here? If you explain me why you are recommending this teacher not to be reelected, when in his last evaluation, it says, you will be reelected.
Right, and boards,
Can I see the evidence? That's what the teacher is telling me. So we are seeing the evaluations, and yes, this is it. Yeah, this is it.
as long as that's done with all 5 board members at the same time.
Okay, so bottom line is that, right, that Dr. Freeman, I think, mentioned that. We can do that in a case-by-case basis if that is our decision. Because something that you mentioned is the board owns the house. But not looking to look at the relevance and numbers and things like that, right? Something irrelevant. But there is something that we need to know, we are going to do. What I can understand, what I hear from Tony is we are being asked to authorize the contract of somebody else. Right? So we are making that decision only, so with your recommendation as a lawyer or attorney on board, because you said that you are perfectly authorize this, just go with what the superintendent says.
If everything's going fine in the district and the superintendent says, I want to keep my cabinet the same, I would not be in a position to recommend otherwise. But I don't know, you know, whether an individual board member. Well, the board has the power to hire and fire everybody in the district. And in fact, if we go back to the teacher non-reelection, the board individually handles non-reelections for teachers too. So you'll get a recommendation, and like you said, if you need to see documents to support it, then you see those documents. Yes, sir.
I did have this, one thing that was brought up was, superintendent evaluation says that we're evaluating him on his ability to evaluate. Okay, if we can't actually see the evaluation, then we need to change the language in his evaluation, because it's where we can't make a specific evaluation on that if we can't see the evaluation. So maybe we need to change the language in the evaluation to better reflect what we can do in that type of environment. So, but I think it's important so we clarify something that you are saying. Maybe we need to change the language if we cannot see that. But it's not that we cannot. We can. But it's not advisable. Well, and then we can. There's only, yeah, like you were saying, unless there's cause to do it, that's not really our place to do it. Yeah. So, in a normal circumstance. So I'm just wondering if maybe we want to change the wording on for Mr. Bennett's evaluation when it comes to that specific portion. Maybe we need to change the language of that, because if we can't see how he's evaluated, how can we evaluate him on that?
Well, you may have missed my point a little bit, Mr. Nielsen, when I said it's a tiny part of his job. You know, the superintendent needs to see to it that the district's running appropriately. You know, I don't know that any superintendent has ever been hired or not hired based upon his ability to fill out an evaluation form. It really turns on whether or not his team is running the district right. And the board will see that. And it's not really about, and I don't know what your board bylaws say, or your board policies say about the evaluation of administrators. So there may already be guidelines in there that you can look at. We can pull those up, but I've never had a conversation with a board where they expressed any concern about the
I'm not saying me and concerned, but if our responsibility is to evaluate him on his evaluations, and we don't see his evaluations, how can we effectively make an evaluation? I'm saying the word evaluation a lot, but how can we effectively do that if that's something that's not even in our scope, unless there's a special circumstance?
Yeah, I mean, ultimately, like has been mentioned, the board owns all the documents. So if you need to see an employee's evaluation, you see the employee's evaluation.
It might be something we're here to think about possibly doing.
I think that is an excellent suggestion. It is, we are doing all of this because our commitment, our nation is to do what is right, what is fair. And we don't want this just to be a show. Yeah, we are evaluating and say, oh, yes, and just raising the.
Oh, yeah, you did a great job. We have
did a
no.
great job. Yeah, oh, yes. No. We are not fulfilling our role as a board members. We are doing that. You know?
Right.
So if there is something that it says, is he, how do you evaluate him on evaluating that? In every aspect of our lives and our roles, we are like that. So I'm really happy and glad to meet with board members and report that that is our commitment, that is our role, that is our philosophy, those are the values. Why we work because our constituents they vote, and we are going to make sure that we do that.
No, we were elected to do.
And that we were able to do.
Yes, sir.
I see a danger of getting too heavily involved in some of these things that really does go beyond our scope. As a teacher of 30 years, when I would do the report cards, each of the principal would just make sure that, have somebody make sure that there wasn't anything missing. They don't go out and let's check it up against my grade book. And I think if what's done here is going to be done here. Otherwise, you don't have a consistent.
Oh, and I fully agree with you, because I'm one of the first people to tell you that that's not my job. We hire people to do that job. We should let them do it. I'm one of the first people to say that. But if our job is to evaluate him on his evaluations, and that's not something in our scope, then I think that might be something that we look at possibly changing the wording at least.
And you are perfectly right. I, as a teacher, I completely agree with you, but also as an administrator, if I get a complaint from a parent or a student, that this teacher is not graded properly based on the syllabus, I'm going to not look on in every book. I'm going to ask on the syllabus, for the book, and everything. And that is something that, as an administrator, you have a prerogative to do if that is a complaint. So we're just clarifying what are the prerogatives and what do we have now. That is something that we know important because we don't want to violate any rules.
Certainly. And there are going to be times, you know, the board will hear grade challenges at the appropriate third or fourth step in that grade complaint process. And then you'll need to see the grade documents. You'll need to see the relevant documents. The board will get involved in classified discipline and dismissals at the third or the fourth stage. And you'll need to see all the evidence at that point. The board, I haven't looked at your grievance procedure recently, but the board, some boards get involved in the grievance process. You'll make an intermediate decision in a grievance at about the third or fourth level. And so the board will need to see the evidence at that point. The key to all of that is making sure that the board's operating at the correct level, which is usually one of the highest levels of government. You get it after everybody's exhausted all the other processes. Complaints, uniform complaints, the board will typically get an opportunity to judge and decide on a uniform complaint at the appropriate level. The key is not to get involved too soon because you can taint the process. And I think that can be universally applied to all of these things. Any other questions? Let's see if we can get a couple more slides. Sometimes I...
He thought it would take too long to go through the 20, and then he said the last guy, well, that should make
can't have tap dance in law school, right? Got to get through the syllabus as quickly as we can. So again, a lot of this comes from your own bylaws and governance rules, so I don't need to read it all to you. But the idea here is that the role of the board is to work with the superintendent to fulfill your responsibilities. And so these are the last couple of bullet points in that board bylaw 9000. You provide support to the superintendent by adhering to your own standards and policies. We don't want the board saying, hey, we want you to handle this case differently than the last one. That's not supportive of operations in the district. So consistency with your own policies and practices is very helpful to your staff in allowing them to implement your vision. Consistently supporting established priorities and goals, same thing. You can change your LCAP each year, but you can't change your LCAP in the middle of the year because that will derail your staff from the path that you've set them on, and everybody will complain. So ensuring accountability of the public by evaluating the superintendent and setting policy for his evaluation of other personnel. Monitoring the effectiveness of your policies. Policies get changed from time to time. Your governance rule book can get changed from time to time. So part of what the public needs to see you doing is evaluating your own policies. And in fact, we'll talk about it in a minute, but there's a board bylaw that says the board should do a self-assessment, a self-evaluation of its own body. And so that part is the transparency in government and the accountability to your stakeholders so that they can see you're doing a good job and doing the job that you're supposed to do. And then finally, serving as a decision-making body. This is what we just talked about. You're the final decision maker with complaints. Maybe not the final, but one of the final stages in deciding complaints and employee discipline cases and grievances in some cases. So those are the things that are visible and that you need to be transparent about, and your public needs to see that you're making those types of decisions in a way that's supportive of your chosen administrators. And that's out of your board bylaw. So your governance protocols come out of your governance handbook. So you've agreed upon protocols, or previous boards have. Those protocols can be changed from time to time, but the ones that are in the book right now talk about a unity of purpose. They talk about making sure you adhere to the rules of confidentiality, which is sometimes difficult. Rules of confidentiality apply for different reasons. There's pupil confidentiality, employee confidentiality, there's closed session confidentiality, and all those things, of course, need to be respected. And those are part of your governance protocols. Of course, your protocols require you to comply with the Brown Act for obvious reasons, but also your own policies and bylaws. One of your protocols is to respect and support the majority vote of the board. So this is the hard part, because there's no requirement that all 4 or 5 board members have to agree. But the established protocol is once the majority has been established, after everybody's had a chance to say their piece, one of the best practices in effective governance is, whether you like it or not, it's the rule now. The majority has acted and voted, and it's best for the optics and for the appearance to the constituents that the board is now unified in supporting that majority decision. Parenthood? Yeah. Depends on who's in charge, though, right?
I completely agree, and that's what we do, right? Here, but I was thinking, and I know this is the lowest level in the democratic process, but legislators, for example, even justices in the Supreme Court, when they don't agree with something, they disagree. And I'm not saying that we should be able to do it. That's totally. But I was just wondering, they create on that, and they give a rationale why they are not agreeing with that decision, right? So the public, they know that their constituents know that why they voted against and why they didn't agree with that. And our constituents, they don't know that.
Yeah, they do. When it comes to a board meeting.
They need to
They
come to the
listen
meeting.
to us discuss it.
Yeah.
We get some really volatile issues and discuss it in the public, and they're sitting there, they want to know, they'll sit right there and watch.
It's It's an interesting analogy, and it also, you know, the discussion, at least to a certain extent, gets recorded in the minutes. The Supreme Court analogy is that the justices can disagree and they can write dissenting opinions, and that gets put in the official record. But after the decision is made, all of the justices support that as the law of the land. And that's kind of the idea that we're looking at here. And then listening to and considering other points of view. I think that's just a matter of courtesy. We don't have to discuss that very much, but it's also important that your constituents and your stakeholders see that everybody gets their vote and nobody's frozen out, and that the board majority or the board is acting after hearing all the opinions, after hearing all the information, and then taking a vote, and then that becomes the law of the land. So I consider that to be a best practice. So there's 10 specific areas that are outlined in your governance protocols. It covers 4 pages of your governance guide, your governance handbook. But the areas that are covered are what's required to develop an agenda. And so there's a lot of rules for that so that the meetings run smoothly. Things aren't thrown on the agenda at the last minute. Board members aren't coming to a meeting without full information because the agendas are prepared in advance. And the bylaws dictate that the agenda is prepared by the superintendent in combination with the board president. And then it needs to get disseminated with the supporting materials to the board members in advance so that they have an opportunity to pose questions if necessary. And that's in here somewhere too. Governance protocols encourage preparation and attendance at all meetings, except in an emergency situation, so that the governance of the district is always driven by all 5 voices rather than 4 or 3, and that all 5 voices are fully informed and have had an opportunity to read backup materials and so forth. One protocol, third protocol is the proper use of closed sessions and adherence to confidentiality rules. The closed session rules are inconvenient, but they are pretty well established, and there's a good reason for them. Government has to be open. That's the bottom line rule. Open government, except when there's a good reason for it to be private and confidential. So real estate negotiations, it's important that that's confidential because we don't want the seller to hear what our position is, and and that's good for the public because you're dealing with public money. So that goes for labor negotiations as well. It'd be great that that be open, but we're the stewards. You're the stewards of public money. You have to spend it responsibly, and you can't do that if you're in a bargaining situation and the other side hears every bargaining goal, every your cap, your bargaining position. So, and then there's the discipline and all of the things that are private because of individual privacy issues. So there's a lot of good reasons for private conversations, but they're very specific, and the rules have to be followed pretty closely. So your governance protocols say that everybody agrees that we're going to follow the closed session rules as best we can, even though they're inconvenient, and that we're going to adhere to the confidentiality of closed session. In some cases, disclosures out of closed session would actually be a crime. So closed session needs to be closed. I have a slide on that, so we'll come to that in just a couple of minutes. And it's all in there. I won't spend a whole lot of your time on it, but I'll give you the high points. We want the board members fully informed so that they can pose questions about the agenda in advance. Of course, you can't do that on a 2 or 3-on-1 basis, but individual board members can check in with the cabinet through the superintendent and say, hey, I'm going to need clarification on this before we get to the board meeting. And that's good for everybody. That streamlines the process. It's efficient. But those requests need to go through the superintendent in advance, because nobody wants to be surprised or have to go through a lot of explanation in front of the public at the time of the board meeting if it can get handled ahead of time. Effective, efficient board meetings with appropriate public comment, that kind of goes without saying. Governance protocol for setting the goals of the district and evaluation of the superintendent, and that's in your handbook. There's a goal that promotes unity and communications to stakeholders. And so there's a couple of different ways to look at board communications. And I've got a slide on that. So we'll talk about that in just a second. Public complaint resolution in accordance with law and district policy. you will get the complaints. You will get the parent phone calls saying my child has been discriminated against and so forth. It's important that those get handled in accordance with law. And in some cases, those are very complicated procedures. In some cases, your people are going to have to call the law office to handle some of these things. If they're real serious complaints with real serious allegations. So the commitment that's established in your board protocols is that those get filtered to the right place. They need to go back to the superintendent and then delegate it to the appropriate department in the district or perhaps to outside investigators to deal with those complaints. Then they'll come back to the board. You'll get all the evidence, you'll get the information, and you'll have to make a decision in some of those complaints, whether the complaint is sustained or denied, and then what's going to happen as a result. And so that's an important protocol. Oversight and participation through school visit and events. So there's a protocol for that. Board members do need to visit school sites. You need to be seen, and you need to see. You need to see how well your school sites are running. You need the teachers and the students and the parents to see that you're out there doing your job, being the stewards of the school district. But the protocols in your governance handbook say, you don't surprise a principal by just showing up on their doorstep. You try to arrange that through the superintendent's office and then through the principals. When you visit a classroom, you're not there to evaluate the teacher because that'll violate the contract. But you can certainly, you're allowed to observe. And you should observe when your schedules allow. And that's all in your governance handbook. And then board self-evaluation, that's one of the 10 protocols, and there's a board bylaw on that annually the board is charged with doing an evaluation of itself as a body. And I've got actually a slide on that we'll talk about very briefly. Let me jump forward. Governance standards say, so this is Board Bylaw 9005. It's pretty lengthy, but it's just kind of rules of conduct that the board has agreed upon so that it conducts its meetings in an efficient and appropriate and beneficial manner. And so there's a bunch of bullet points there that come out of Board Bylaw 9005. Again, you're going to see a lot of these that appear both in the handbook and the bylaws and perhaps in the Brown Act, like keeping confidential matters confidential. Like I said, it can be actually a crime to disclose confidential information out of closed session without the direction of the majority of the board to do so. Governance standards include participating in professional development. You have an actual board bylaw on that. I'll talk about that in a second. And then, to understand the distinction between board and staff roles, one of the rules that it may have been on a previous slide, but the board is precluded from commanding the services of any district employee, I think is the language. What that means is individual board members don't have the authority to go to a school site and say, Secretary, I need you to gather up these documents and give them to me. That'd be a violation of your board bylaws. Now, the board majority can direct that happen. And then they can direct a certain person to go make that happen. But that has to be a decision of the 5-member board and not an individual board member. And that's kind of the bottom bullet point there, understanding the authority rests with the board as a body that acts by majority vote as opposed to individual action. We talked a little bit about board statements. This is out of your board bylaw 9010. And of course, board members get to express individual views. Your agendas probably have board member comments, most districts do. Your constituents expect to hear what your views are. And so, of course, you're permitted to do that. You can do that within a board meeting, of course, but you can also do that as an individual. However, to ensure communication of a consistent, unified message of the district, individual board member communications need to be identified as such. You need to be able to say, I'm speaking as myself to my constituents as an individual board member, and here's what I have to say, and I'm not speaking for the entire board, unless, of course, the board has given you permission to do that. Board communications typically will go through the superintendent because he's the liaison, but sometimes from the board president.
Thank you for clarifying that, because I always thought that when I thought as a board member, when I get talking rules, small rules, I said, as a community member, like any of you, not in my role as a board member. But you are saying that I can talk as a board member, not on behalf of the board, but as an individual board member.
You are always a citizen, and you will always retain all your rights of a citizen with some narrow exceptions, meaning you have to follow the Brown Act, but normal citizens don't. But other than that, you retain all the rights of a citizen. You got free speech rights, you can talk to people, but you can't represent yourself as the board or as the district unless you have the direction from the board majority to do so. Yes, sir.
It's interesting you say that because, first of all, as a parent of students in the district, I have to, if I'm having a conference with a teacher, I have to go out of the way, I feel, to say, look, I'm here as a father, not as a board member. And whether or not they believe me, I don't know.
Right.
I mean, I can't.
They'll still be nervous.
I can't force them to believe that.
Right.
Fortunately, all of ours have been positive. But they can be, and the same way with social media. I mean, you get people, don't express your opinion on something that relates to the district on social media because they're going to start jumping all over it.
Yeah, and I'm going to touch on that too. There's additional problems to that. But what you just described is right in the governance handbook. If you are speaking in the district as a parent or as a citizen, it's very important that you do exactly what you just described, is try to convince people that I'm here to speak as a parent or just as a citizen, not as a board member. Right, yeah. Maybe they'll believe you. Yes, sir.
Just something that we constantly get these emails. I never respond, just out of safety. Not safety. Sometimes I feel bad because I might know the person, but I won't respond. That's correct, right, to do that? I mean, I know I could, but.
That's extra cautious, and so I will never say that's bad to be extra cautious. I would say that it would be almost as cautious to just simply say, I received your email, I'll be forwarding this to the appropriate person, and you'll be getting a response from the administration. I think that serves both purposes. It makes it clear that you can't get involved, but that you've heard them and something's going to happen. So I think that's an appropriate balance, whether it be in face-to-face conversations or by email or social media.
Well, even that makes me a little uncomfortable because I don't want them to think that they come to me and I'm running straight to the superintendent.
Well, your board bylaws say that you're supposed to do that, though.
Yes, but people will abuse that.
Well, what you really should do is they go through the process, that goes to yeah. Because not everything needs to go to the superintendent first, just because they have access to you. They should still be following the process of trying to get satisfaction on their grievance or whatever it is at the appropriate level, not necessarily at the superintendent level.
Well, and that's a good point. That's a variation on what I said. Rather than saying I'm going to forward this, you can just say you need to call the superintendent or call the principal.
Mainly the emails. We all get them.
And you're right, Tony. Sometimes, in my experience, they call for something that is valid, and another one says, maybe you want to let Mr. Bennett about this is something that. But on the other hand, we need to be conscientious that sometimes it has an effect, that it is only one member instead of the superintendent, because we are humans in our system, and that can help both the process that we are supposed as administrators to follow, and that sometimes it gets into some habit, this is speeding up, moving forward. So,
As a teacher, a parent came to me and was complaining about the principal, I'm not going to go investigate it, I'm going to go talk to the principal. And let him run as they see fit. Getting myself involved in an investigation directly, as either a teacher or a board member, would seem to me to be counterproductive.
Well, and unfortunately, some mistakes can be made too. We are doing more and more training on how to avoid mistakes in investigations. The new rules regarding Title IX investigations are onerous. I don't even do them because I haven't gone through the training. We have specific people in our firm that do the high-level Title IX complaint investigations. But, how you handle an investigation determines how the lawsuit comes out if people don't like the outcome. So that's a good reason why, a lot of times we say stay in your lane. So we would want the teachers to stay in their lane and not get involved in investigating things that should be sent up to the administration and handled either by child services or by HR. those kinds of things, so that the trained people that know the policies and can find out how to follow the laws can do that without getting in trouble. And to a certain extent, I think that applies to board members as well. I don't think I'd want the superintendent doing a Title IX investigation either. He needs to govern this whole operation rather than spending hours and hours talking to people about nitty-gritty types of complaints. So maybe the answer to that is we have people for that in this organization. Whatever comes up, we have people for it. And then ultimately, those people are the 5 board members at the right step in the process, wherever that happens to be. The last bullet there says coordinate all media statements through the superintendent and appropriate staff. That's not verbatim out of your policies, but that's what I would call a high-level best practice. The media is very adept at getting information that maybe they weren't entitled to or that they can use in a different way. I'm dealing with a district that's getting slammed in the media all the time, and it looks like, to me, that the articles are being written by the plaintiff's attorney that's milking the district for all the money that they're squeezing out of them in these lawsuits. And that district has learned the lesson that there needs to be one single voice to the media, coordinated voice that has the experience to do that. So a lot of districts have a PIO, and those that don't can hire media consultants when things get difficult. But it's very important for the district to have a protocol, and you do have a protocol that says media, the responses to the media need to be coordinated and not go through a variety of different people. Now, board members are allowed to talk to the media. You need to use your judgment on that. If you're speaking for yourself, you can speak to the media. If you're speaking for the district, you can't do that without board approval, and the board's protocols already say it always needs to go through the superintendent and staff. So my strong recommendation is only talk to the media if you're speaking as an individual and not on behalf of the district. If you're going to say anything on behalf of the district, it needs to go to the superintendent because there's a lot of planning and a lot of expertise that goes into responding to media requests. Is that how you handle it here, typically? Candace is the head honcho. There you go. All right, we're at the next slide. Public statements. So I'm switching kind of the social media that you mentioned a minute ago. Social media and emails are just another method of communication. Very efficient and fast, so you're going to have to communicate with your constituents and also with your district, at least through email, but sometimes through social media. The important thing is there's a pro and a con to social media. It's so fast and so widespread that the horse can get out of the barn real quick with social media. But the rules are the same. The standards for communication are the same standards as any other board communications. You have to speak as an individual or as the spokesperson of the board if you've been so designated, and try to do your best to identify personal statements as your own personal statements and opinions, whether it be in emails to constituents or social media. Recognize that there's an additional potential for serial meetings. A Facebook post is generally like a billboard. So if you put up a billboard up here on the 215 that says, I'm going to vote blah, blah, blah on the next upcoming thing, and your fellow board members drive by and they all see what you just said, that's a serial meeting that just happened on the freeway. So you need to moderate what you post on social media because it's a billboard. You can say what your values are, especially during campaign time. Everybody's going to be on social media saying, I stand for this type of curriculum, or I stand for this new approach to student discipline, or whatever the new thing is, you can stand for it and you can say so. What you can't talk about on social media, my advice anyway, is any matter of business that's coming before the board. So I would recommend against putting on social media, I just read the proposed LCAP and I disagree with this part of it. That's a matter of business coming before the board. And if you put it out to the public and two other board members see it, you've technically committed a Brown Act violation. That's a lot of words for a minor thing that hopefully will never happen, but it's one of I got challenged very strongly on a social media presentation I gave to group of board members. And so I had to really come down with a concise best practices statement on social media. Yes, sir.
I just want to kind of give you my process.
Me too.
What I normally do is, if I need to send information to the board, I'll do it on email. I do BCC so that they respond to the meeting. Instead of all the other five board members.
Yeah, and when I send an email to all board members, I get to do that occasionally. I always put in there, please remember, the Brown Act precludes you from responding to me or to each other. Individuals can respond, but only up to 2 individuals. And I would be in the same position as your superintendent. So you do your Friday memo by email, you do the BCC, so nobody can accidentally hit reply all. That's brilliant. Reply all is deadly. In fact, my firm implemented a drop-down or a banner that pops up. Are you sure you want to reply all? Because our communications are privileged, and if we mess that up and send it to the wrong person, suddenly we lose privilege. And so I do that maybe once a year, is my confession, and it was yesterday. So I have 361 more days with no mistakes, or I blow my record. It was not a confidential communication, but I sent it to the wrong Patricia. Anyway, we all do it. Yes, sir. Yeah, yes, Candace. Sir.
I just want to make one comment as it relates to social media. I have not seen this happen in this district, but in a neighboring municipality. What we see happen a lot of times is community members will get involved in a conversation and then they'll tag an elected official. And then that elected official will then begin, okay, I'll look into this, I'll have this taken care of. And so I just wanted to bring that back around because that's the same as you were talking about, the email conversations and that kind of thing. And I don't believe many of you are that I see anyway, active on social media, but I think it's a dangerous trap that some of them are falling into.
And that reminds me of an example I used to give. If a labor union president emails you something about what they're concerned with during negotiations, and they send it to all 5 board members, and the board members don't respond, but then, the bottom line is, now I can't even remember my example, but the issue is giving somebody else the power to throw you into a Brown Act violation because 2 people have exchanged an email, and then it goes to the union president, and the union president sends it to a 3rd board member. Brown Act violation, arguably. Are you going to get in trouble for that because it wasn't your fault? Maybe not, but it's probably at least going to cost you 1 phone call to me to make sure we smooth out the footprints in the concrete on that one. But yeah, you can get thrown into a Brown Act violation easily by email communications because it's just so easy to forward these things. Probably not going to happen. So social media, subject to the same standards. Board member communications, just remember a lot of what you do is going to be subject to the Public Records Act. If you're doing it from home on your home computer is arguably now subject to scrutiny under the Public Records Act, under the San Jose case. I don't know if you've had any training on that. That was a real problem, but yes, sir.
I'm probably the only one that doesn't have a district permission. Everything I do goes on there.
That is a best practice. Communicate only through the district server, and then you know for sure that your own private data is not subject to scrutiny. Doesn't mean your private stuff would get disclosed in the Public Records Act, but somebody would have to actually evaluate whether you've got district documents mixed in there too. So the safest thing to do is keep district communications completely out of your personal devices. I hate text messages, by the way, so same thing. Your personal cell phone could be subject to scrutiny if you use it to send text messages or emails regarding district business, so watch out for that. Yes, sir.
On the other board that I was on, the superintendent was having that problem where they were trying to get into his personal text messages and stuff on his phone. So what he ended up doing is issuing everybody a phone.
Now, some districts do that. Some districts issue everybody a computer. It's a budgetary question, but it also facilitates getting work done using district equipment and district servers rather than home. The other way to do it is communicate in ways that don't implicate your personal devices.
Just to clarify, this, you mentioned that
right?
So what are the pros and who?
Public records requesters and any opponent in litigation in a discovery request. So they're not entitled to your personal stuff, but they're entitled to force you to sign an affidavit saying you've reviewed all your personal emails and anything that's district related, they can have access to. So the real issue is not that your personal stuff's gonna get disclosed. The issue is, don't try to hide anything on your own personal device, because it's all subject to review now in a discovery request or in a public records situation. Subject,
It not takes your device.
right,
You review it and then sign an affidavit saying that you reviewed it and there's nothing pursuant to that request.
and
Yes, yes, I'm sorry, go ahead. As long as we state if you have PUHSD email, it goes to your server, and you have it anyway, right?
The emails they have, yes, but if you're keeping something else on your phone besides emails from a district server, that could be considered district business.
that's the text messages in particular. That's why I cringe about text messages. We never know what's gonna come up in litigation.
You download files to your phone because you want to review them, those would be considered PUHSD materials, that type of stuff.
Anyway, I don't mean to get so scary. It's usually not a problem, but just be aware that anything that's district related is arguably subject to disclosure unless excluded by some specific law. Confidential information never transmitted via social media or non-district, I should say, devices or servers. That's exactly the point that Mr. Nielsen just made. As long as it goes through a district server, it's in the district's hands, and the district would handle it appropriately. But text messages are not confidential. Emails are not confidential necessarily. They may be protectable, but that doesn't mean that people aren't going to get their hands on them. So we always avoid that. So we're still in the board bylaws. I'm kind of going through in number order. We've covered some of these things because they're also in the governance handbook. Limits of board member authority just basically means that board members act as a body and not as individuals. Individual members shall not exercise any administrative responsibility. So your board bylaws say board members don't get involved in the day-to-day stuff. You delegate, and the superintendent then delegates, and then the workers actually do the work. And the board members shall not command the services of any school employee. That's in every board district's bylaws that I've ever read. And the point is, the board is entrusted in making high-level decisions and not getting down and dirty in the trenches doing the actual, I'll say the ditch digging. That may be derogatory, but sometimes it feels like all the work is like ditch digging. You guys are the supervisors, and the workers do the work. Individual board members shall submit requests for information to the superintendent. The reason for that is that the superintendent can then disseminate that information to all 5 board members and control that information in a way that complies with the Brown Act and confidentiality rules. Board members should not be going to the school site secretary asking for information, because the school site secretary doesn't know all those rules. And it's also important that the response then goes back out to all 5 board members, so the playing field is level, as I mentioned before. Individual members who are approached directly by a person with a complaint shall refer the complaint to the superintendent or designee. So that's right in your own adopted board bylaws. The complaints need to go to the administration so that they get handled through the correct procedure. And if and when it's appropriate to go back to the board, it'll go to the board at the right time, and no individual board member is tainted or has more information or less information than any other. That's that. Slide 13, we may make it. So board meeting protocols, this is Brown Act and Board Bylaw 9320. And you've probably received training on this before, so I won't take too much time. But the definition of board meeting is very broad. And it just means that anytime 3 or more heads, board member heads, get together on any subject that's related to the district, that's a meeting. And the reason I say heads, that could be by phone, it could be by social media, it doesn't have to be face to face. And it could be a string of communications that put 3 heads together. It doesn't have to be 3 at the same time. That's the serial meeting. So bottom line is 3 members can't talk about district business unless you're in the middle of an appropriately agendized and noticed board meeting. And there's some exceptions. You can go to CSBA, you can go to graduations, you can go to award ceremonies together, but you can't sit and talk about district business together. So board members are held according to the following standards. This isn't in your policy. I didn't find it anywhere, but I assume you typically follow some kind of parliamentary procedure, typically something like Robert's Rules. So that part is a best practice. That's not right out of your policies. The reason it's a best practice is so everybody can anticipate what's going to happen next, and nobody. I mean, I've seen board members before say, "Wait a minute, I didn't get to discuss that." Well, your time to discuss that was after the second, or and before the vote. You can't talk about it after the vote. Well, I didn't know that was a rule. So, adopting those kinds of rules keeps board meetings running smoothly, and keeps individual board members from being left out in the cold on an issue if they wanted to discuss it and didn't get it in there. Board members are held in public. Well, we know that. There's rules about where it can be held and when they must be held and how long they could be. Your board bylaws say board meetings have to end at 9 o'clock unless extended. I mean, that's probably a good rule. But there's lots of rules that talk about where and when and how long. No serial meetings. We talked about that. That means board member 1 talks to number 2, talks to number 3. Boom, that's a Brown Act violation. Closed sessions are conducted only in accordance with law. We know that. We'll talk about that a little bit more in a second. All meetings conducted in accordance with law and board bylaws. It's repetitious, but that's probably a good thing. That's in both that's in your board bylaw that way. And then finally, all board meetings must provide opportunities for public comment. We know that. The rules can get a little complex, and that's probably a different presentation, but the bottom line is your protocols call for respect of the public's right to speak. That's the public's opportunity to say their piece about how they think the school district should be run or is being run and so forth. And it's a fundamental part of our governance process. So all boards are encouraged, and I know this board does, respect the public's right to speak at every meeting. So we talked about closed session. These are most of the closed session, the approved closed session discussion topics. Some of them you don't probably ever get involved in. I don't usually see threat to public facilities. Occasionally I do. Liability claims should be used more often than it is. But it's the other ones that typically come up. And so there's about 8 bullet points there on the typical and most important closed session discussion topics. The employee ones cover hiring and firing and kind of everything in between. But they come with special rules. So if you're going to do discipline, dismissal, release, that's all you have to say. It's a confidential process, and no more information goes in the agenda. We don't necessarily want to call people out publicly if we're going to discuss a discipline topic. It's confidential. But then the board can go into private session and discuss disciplinary matters. There's very specific rules about when you're hiring somebody, particularly executive level people. There's new rules about whether you can do that in an open session or closed session or regular meeting or special meeting, and what you can say and what you can't say. So that's for another day. And my team's able to assist your administration when those things come up. Because there's a brand new rule from last year that says you have to give an oral statement before the approval of any administrator contract, executive level. And that's been interpreted different ways, but of course my law firm interprets it correctly, and we'll give you that advice when necessary. So there's a lot of rules that go into how you agendize these things, and then how you handle them behind closed doors. And then, of course, when you go back out into public session and do the report, there's certain things you have to report, certain things you don't. And the key to all that is it's in your bylaw, it's in the Brown Act, and your administrators are entrusted to know and follow those rules. And so please take their advice on those things because they can be complex. And that's really the issue here, is that the highly effective boards do their best to comply with those rules and take the lead of the administration when you ask, hey, can we talk about that in closed session? If the answer is no, then you got to find a way to get your business done lawfully in another way. I'm going to say it again, board members shall not disclose confidential information received in closed session to any person not authorized by the board. The reason that's so important is because that's actually a crime, and we don't want anybody getting involved in a misdemeanor for accidentally disclosing confidential information. So That's why I don't know if your administrators collect all confidential documents in closed session. It's not because they don't trust you with them, it's because they want to protect everybody from accidental disclosures. Any questions on that so far? I'm going a little fast. Yes, sir.
I have a question. Only matters announced in open session or the agenda shall be considered in closed session. So if there is a disciplinary item, it has to be there on the agenda for closed session?
If it's employee discipline, all it has to say is public employee discipline, dismissal, release. That's all it has to say.
Yeah,
No name, no number.
It has to be public, personnel release, staff member potentially release.
Yeah, well, you don't have to say that much. I would never be that specific. I would just simply say exactly what it says up there. Public employee discipline, dismissal, release. That's all you're required to say. Sometimes in certain situations, you have to give the title of the position, but not for discipline.
So it has to be public employee discipline in order for us to talk about it.
Yeah. Now, I've seen some boards that like to say personnel issues on the agenda. That's not unlawful as long as it provides the public with enough information. And I can go on for an extra hour on Brown Act sometime. This language here is what they call safe harbor language. If you use this language the way it's expressly set forth in the Brown Act, you have a layer of safety that's almost impenetrable. If you choose to use different language, that doesn't mean it's unlawful, as long as it complies with the spirit of the law, which is the public needs to be informed of what's happening. But why not be safe and have that safe harbor protection? I always recommend boards use and districts use the specific safe harbor language in the Brown Act.
Ours actually does, our agenda will always have this on there, and that's why in closed session, if I've ever spoken to you as a board about a discipline dismissal regarding an employee, I am speaking to you because we have agenda items in closed session, right? There's also part of the government code, and Mark talked about that too, that if as a board we can actually take action on an employee in closed session, dismissal, then they have the right to have that, the accusations heard in public, if they so choose, so they have to be informed ahead of time, not that they make a decision. So it's always going to be on our agenda, stay closed.
It's an interesting.
Clarifying that, yeah, I remember that. The direction of my question or the objective is because we have tried to address some situations that we should perform in closed session, and we have been told no, because that has not been given on the agenda of closed session, right? However, here it says only matters announced in open session. Can you clarify that? It doesn't have to be on the agenda 72 hours before, but we can announce it in open session, that we are going to be talking about that?
Maybe the word "or" is inappropriate. You may have caught me on that. There's an interesting part of the Brown Act that says, and I may need to write that differently, because the Brown Act says you have to announce the matters that are going to be discussed in closed session. Now, our opinion has always been, and we've never been wrong or challenged on this, is that writing it on the agenda is the same as announcing it before. So there's two different rules that apply here. You've got to put everything on the agenda. That's a basic rule. The Brown Act says, if you read it verbatim or strictly, if you strictly construe it, it says after the agenda, you go to the board meeting, you say the Pledge of Allegiance, you do everything you need to do. You have to announce the topics that are going to be discussed in closed session. We don't recommend you need to do that. It's written down. Everybody that's there knows about it. Now this says only matters announced in open session or on the agenda. It really should be and. You're right. It has to be on the agenda, period. So that's an incorrect or, and I'll fix that.
I thought it was right, so we could maybe announce it.
You got me. No, I mean that's because that would violate a different rule that says everything needs to be on the agenda 72 hours in advance, posted. Oh, there's a brand new rule, by the way. I think I sent a Christmas email to some of my friends about having a direct link to your agenda now on the front page of your website. That's the new Brown Act rule for the year, and we get a new one every year. So that's.
So now when we are on closed session, and we are talking about something related to this, but it's not action that we take, but it's an agreement that we make. But we don't take minutes, there are no minutes for closed session.
Very rarely would there ever be a minutes for closed session.
How can we refer to that, in this closed session, we agreed that we were going to do this and everything like that, because then people forget things.
Well, most things that the board does needs to be action. However, what you're talking about might be, and a good example would be if you meet in closed session with your attorney and say, attorney, we want you to try to settle that case for less than $10,000. That doesn't get reported out. There's no minutes. And the board, that's kind of a consensus thing. And some people say that's not appropriate. I would say that is appropriate because the board's not taking final action on something that requires a report out. You're not required to report out your directions to your attorney on how to deal with litigation, or your direction to Candace on how to negotiate the purchase of property. Those kinds of things where you're giving an interim, let's proceed this way or let's proceed that way, as opposed to we vote to approve that settlement agreement and we're going to sign on the bottom line. Because that thing gets reported out. And it gets,
Whenever we're giving guidance on which direction to take, there's no action or anything done.
it,
Then it doesn't need to be reported out.
yeah, I think the analysis should be in the other direction. First, look at the Brown Act and see if what we're approving has to be reported out. And if it does, then you need to take a vote. And then when you report it out, you have to report the individual votes of all the members. If it's not something that the Brown Act says you have to report out, then it's probably something the board can just discuss as long as it's an agendized and announced closed session item and give direction under that item. And so there's a lot of things that don't have to be reported out. And I would say you can do those by consensus because there's no difference in this between this and saying yes or no on a vote, except whether the vote has to get reported out. I should be careful about encouraging you too much to do things just by consensus and thumbs up. If it's an important decision and the board's making a final decision, it always should be a vote, and then it gets reported out according to the Brown Act rules.
We did get a legal opinion when this question was asked early last year, different law firm, sorry. But same answer, so that's good.
They must have been right.
But the final answer was that for these reasons, we recommend best practices, board members not take votes.
Take votes?
Notes.
Oh, notes.
Have notes. Notes of decisions.
Yeah, and that was when you started saying about last year, but I don't think you addressed that about the notes. Individual notes.
No.
Recordings, yeah.
Yeah.
It would be a bad practice. That would be something that might get discoverable in a lawsuit. I've got a lawsuit in another district where where the opposing party is extremely aggressive and they're demanding testimony from board members that we're going to fight real hard against. They're demanding information out of closed session, which we're saying is illegal. And they're filing motions in court saying, well, if anybody took notes of what happened, we're entitled to those notes. It's a very rare and very aggressive situation that hopefully you'll never be involved in, but it would be much better for me to be able to say, nope, they didn't take any notes and there's no recording. Occasionally, if a board gets in trouble, they'll be ordered by the court to start recording their closed sessions for the next year. And that's not likely to happen here. I know of one district where that happened within the last 15 years. But yeah, other than that, it would be a bad practice to keep recordings or notes from closed session because you don't know where they're going to go and you don't know who's going to be able to either lawfully or unlawfully get their hands on them. So, all right, it's 6:01. We can stop, or I can power through a couple more slides, or we can just have a discussion. I'm at your service. Want to keep going for a minute, or? Some of these are going to be quick. We know about public comment? So we know about public comment in this district, so it's 3 minutes per person, 20 minutes per subject. That's lawful. You're allowed to put rules in place so that you're capable of getting your work done. You've got a lot of work to do in a board meeting. You can't spend hours and hours listening to endless people talking for endless times on the same subject. But they are entitled to speak. This is their opportunity to speak. It's one of the most fundamental free speech situations. So we got to be respectful. We got to hear them out. But your policies and even the Brown Act will preclude you from anything more than just a clarification kind of response. You don't get to answer to their concerns while they're here at the microphone. What the board can say or the board president can say is we're going to refer that back to staff to look into it. You can ask a couple clarifying questions, but if it's not something that's on the agenda, you can't engage in a discussion or make any decisions.
We have people who try to call out a complaint about a board member or a staff person in a public comment. Do we allow that, or do we say just that we are going to stop here because we're not going to allow people to be attacking somebody's reputation in the meeting?
The law says they're allowed to do that. But the board, and I encourage boards, I've actually written a little script on this years ago. I would encourage the superintendent or the board president to remind people that there's a process and that they may be tainting the process by throwing public information out about a problem employee or whatever it happens to be, and encourage them to go through the process. If they want to take their 3 minutes and criticize a principal for 2 minutes and 59 seconds, they're legally allowed to do that, and there's nothing you can do about it. There's case law out of Moreno Valley on that, actually, just down the street. Our favorite Baca case. I've seen it get really ugly, and the best thing you can do is just sit there, give them a poker face, and now, if they start disclosing confidential information or pupil information, there's probably a point at which, you're going to have to try and stop them because that's not protected speech. If they don't stop, I guess you need to put it into a situation where you can call it a disruption and then invoke the process to clear the room and call the cops. And I've seen that happen. I've been present for a few of those. Hopefully it never happens in this district, but you are allowed to stop a meeting and clear the room if there's a disruption, whatever that means. Because the purpose for the meeting is not for them to have their peace. The main purpose for the meeting is for you to get your work done. Yeah, and they're supposed to be allowed to say their piece, but they can't do it in a way that stops the board from getting its work done. Careful. They have a long memory. So I won't read any more of that. Board actions by majority vote. The definition of action is very broad, so anytime the board comes to an agreement or takes a concession, concurring decision, it's still an action. Whether it gets reported out is a different question, but anytime a board does that, it constitutes an action. It needs to be in a meeting. You have to record the board minutes, including the individual votes of every member on every item now, whether it's closed session or open. That's a fairly new rule. Professional development, your bylaws say that the board should engage in professional development opportunities, go to meetings and workshops, CSBA, whatever it happens to be, and that you should report back to your other board members if you go to a meeting and learn something interesting or important, and that the district has to, in your bylaws, I'm not letting any cats out of the bag, but your bylaw says the board has to apportion some funding to send board members to those kinds of opportunities. And so I guess to bring it back in the framework, highly effective boards take advantage of those opportunities and do their best to educate and inform their fellow board members so that decisions can be made with the latest information about the newest technology and that kind of thing. The last one is highly effective boards do a self-evaluation. That's right in your bylaws. So if you haven't been doing that, you might consider putting that on one of the board meetings late in the school year to just have a self-evaluation on how well you think you've done and how well you think the district's doing. The thing is, it needs to be an open session. So the message should be delivered in a way that promotes transparency, confidence from your constituents. It shows unity of purpose between the board members. It's kind of your opportunity to say, hey, we've done a good job. Times are tough, budgets are tight. There's bad stuff in the news and districts over there, but we think we're doing a pretty good job. And that's right in your board bylaws. So that's all I have. I am willing to stay as long as necessary to answer questions, but I think you've got one or two other things to do. I think I'm staying for closed session too. But if you have any questions right now, now's the time. Yes, sir.
Just a couple of things that you talked about protocols on school visits
So there's some things to think about there, and I'm looking at page 10 of your governance standards, and there's 6 bullet points for protocol on school visits. The thing to remember is you're a person, you're a normal human being person, but that's not necessarily the way that you're perceived by the teachers and the staff members. You are the boss. You are the boss's boss. And so there's going to be some anxiety if a board member drops by and wants to step into a classroom unless it's prearranged. So keep that in mind. Now, do you have the right to do that?
Yeah, that would probably be the best way to answer. Yes or no? Can you do it or we can't?
As an individual board member, you only have the rights of a citizen. Okay. So to the extent a citizen can drop by and observe a classroom, parents can do that. They're very much encouraged to make advanced arrangements so they don't interrupt testing, blah, blah, blah. Make arrangements with the principal. So my recommendation is you only do that after making arrangements with the principal and let your superintendent know, because it can create anxiety or even a grievance from the union. If the union's upset on a Monday and you show up in a classroom and that teacher goes, I just got observed by a board member outside of the contract, you could get a grievance on that. So you want a yes or a no answer. There are circumstances in which it would be legal. My strong recommendation is that you make arrangement and follow the protocols. Is that acceptable or not acceptable?
Because what would be the objective? Talking about the grievance from the teacher and the question. If we call the superintendent or maybe the principal, right? If the principal knows that, the principal is not going to tell the teachers, hey, a board member is going to come and potentially visit the classroom. It's just as a courtesy to the principal to know, hey, a board member is going to be there, and if the principal is busy, okay, who else is going to be with the board member, maybe an assistant principal and myself. But the reality is, a principal gets a phone call, hey, a board member is going to stop by, he would like to look at some classroom. Okay, that's fine. Yeah, thank you for letting me know. But if we're secretary, the board member just came to know about the so we know and then I know who's going to pay. But we don't tell them that to the teachers. Or is the principals, are they supposed to make it?
I would strongly recommend a principal let a teacher know. Even if you're a parent or a citizen, you're not going to go barging into a teacher's classroom without arranging it, because you're disrupting instruction is what you're doing. So my strong recommendation is to follow the protocols, make arrangements with the principal. The principal will let the teacher know, and because otherwise there's going to be rules in your contract that say when observations can occur and under what circumstances, and if they perceive that that's a violation, you may end up with a grievance. So coming back to your yes or no, you deserve a yes or no answer. I'm going to say no, you don't have the right to walk onto a school site and enter a classroom.
Again, well, the end of the classroom, that's not what I said.
Okay.
Visit a school. Many times I'm riding right by Penicati or Heritage and say, I should go in and say hello to them. I'm right here. I should go, I have the time, I just want to say hello. It kind of encourages them, but I don't go in because I need that answer.
Okay, well, the answer is, just like any citizen, you need to check in at we'll look at the policies, but I'm confident that your policies say visitors have to check in at the front office and get permission to enter the school site. So if you're an individual board member, you're the same as a citizen, and you need to do that. That means permission of the principal. And that's just a necessity of the modern age. It's not because you're a board member, it's because you're a citizen. Thank you, yeah. So you have access to the school site just like any other citizen does, but you got to follow the same rules as any other citizen. And certainly a principal would probably be making a mistake to say, welcome, Mr. Board Member, let's walk into classroom number 1 and see what's going on there. I have to advise against that because it's going to cause anxiety and potential problems. Yes, sir?
In 30 years of teaching, I have 16 principals, and there isn't a single one of them who would tell the teachers 2 days in advance so we could have our bulletin board straightened up and out of the room I tell them 20 stuff. Not one of those principals wants their teachers to be surprised because they
Mr. Stratford, I hope I've answered your question.
Yeah, but
I'm going to give you the no.
Well, it's, I think it's a missed opportunity for the school to tell you the truth.
Let me just
Have the
clarify
time to
something.
say that.
What you are saying is that you have your own key and you are going to go there into the school.
No, no.
No, you were talking about what he was
Yeah,
saying.
following
Go
those rules.
there, principal, I'm here, can I, somebody can go and visit the classroom. And I have a question for Mr. Panish here, because now I'm thinking, right? We have something in the contract that it says, it is my understanding that walkthroughs, the only thing that is contractual is when you are going to do a formal observation. And there are certain number of, there is a part, the steps and notifying in advance, and the conference and things like that. But for walkthroughs, just 5 to 10 minutes, you don't need to tell the teachers that, hey, I want to go. For administrators. For an administrator, yeah, Mr. Bennett also can go without any.
Yes, we technically are not administrators if we're on here as citizens. As an individual board member, we're not technically administrators. That's what he's saying. Is that we are citizens, not administrators.
You're not gonna get on the Paloma 5 minutes before the first one, or 5 minutes after the last one. Anyway, you're not getting through the gate, they won't listen. And I understand why, and I agree with it. So, and it may be okay for us to, if we have time, but that doesn't mean they do. I mean, they could be doing all kinds of things that just that 5 minutes that we wanna come in is gonna be disrupting their entire business.
Your guidelines call it a professional courtesy. As a professional courtesy, trustees will contact the principal and superintendent when they plan to visit a campus. It's, I think, primarily to avoid disruption and to avoid the anxiety that's going to happen if a board member pops into a work area.
Just so you understand why I question that, I worked in schools, I know each side, I know probably most people in the district. So it's like, for me, it's a little different. But
Yeah, now if you pop,
I do follow, I do stay away because of what you're saying. I follow what you say, is my rule, but I was just wondering, am I doing the right thing? I feel guilty about it, I'm not doing it.
no, I think it'd be appropriate to check in with the principal if you want, but as a professional courtesy, you'd want to let the superintendent know. And if the principal has time to, show you the new tennis courts, that's one thing. But popping into a school or classroom unannounced is, I think it's problematic. I've seen lots of grievances along those lines, not necessarily with board members, but superintendents.
As long as he doesn't go to the classroom, but he can go on campus.
He's got to follow the check-in procedure. Yeah, you guys need to follow the check-in procedures as any other member of the public.
Because, I'm a facility person, I like to
Now,
and see if the things are running.
maybe a better way to handle that is arrange.
And that's kind of an evaluation in itself, though, is seeing how things are running and stuff like that. That itself is kind of an evaluation.
Maybe arrange a
But
tour.
he's going to report that to the superintendent, because I agree, because our students deserve that the campus is properly maintained and neat.
Clean.
And that is our responsibility. If we just see it, and I know, Dr. Freeman mentioned something really important, the pony, what do you?
Dog and pony.
Dog and pony show. So, we call it courses, right? 2 days in advance. But for me, it's mostly, because I'm a teacher, and I don't care who comes into my classroom, or who is coming to the classroom at any time. I even have a problem with an AP who was evaluating me, because she wanted to set up the evaluation day and time, say, any time you can come and visit.
You better give my wife 2 weeks notice before you come in the house.
So, but that's what it is. So I agree that as long as you follow it's a, don't talk to the principal, sign in, walk around, as long as we don't get into the classroom, we can look into the contract and specifics to see if it just says that for the walkthroughs, and I want to make that also there. That's something that we do. I want to show them the best things that are happening.
Yeah,
And I know.
I've had principals sitting in a classroom and say, oh, you need to see this teacher. Well, maybe I shouldn't, so.
Yeah, you have a specific board policy on your visitation policy, so I don't have it in my book, but you might want to take a look at that and just make sure you follow those procedures for visiting that apply to any other citizen, and then you're okay.
As long as you're not renewing your manual, so you really want to be, I think, kind of concluded and understand that, a principal's focus from the board, from a principal perspective, if I'm a principal on campus and I hear a board member on campus, whatever I'm doing at that moment, drop it. I'm gonna drop it, and I'm gonna make sure I can take care of the board. I think that's the only perspective that just to consider when you walk on campus. Principal, you're thinking, I got a board member on campus, we want to make sure the board is checked in, so whatever I'm doing, is now just got pushed aside, and I gotta make sure. And that could have been something that needed to be taken care of at the time. So giving them enough time so that they can budget that time is I feel would be important as well.
That's what I've been following. I passed by and I think, gosh, but I don't know. I agree with what you're saying. Well, I come through the DO.
Or arrange a tour so all 5 board members can see the site. I think you'll get the dog and pony show, but maybe that's good.
Well, you do. I think I was up. But it's okay.
Well, I appreciate the extra time, and I'll let you get back to your business. I guess I'll hang around for a couple minutes. There's at least one thing on closed session. I'm going to let you inform.
One's a violation of written code and the other is
There are not a lot of clean lawyer jokes. I'm going to use that.
I didn't hear like two words. Well, every once in a while I was like, do you have anything in here? Well, not the DO, yes, but, well, the school districts, the school sites aren't either, yes, but I'm sure they don't.
there are 3 teenage girls in my kitchen. Not one of them was my daughter.
Oh, wow.
Hey, you've got your water bottles.
I'll get it in the recycle. Sure.
Thank you so very much.
At this time, the invitation to address the Board of Trustees, closed session items only. Are there any at this time? None at this time. Thank you. Item 7.1, to adjourn to closed session. The Board of Trustees will discuss items listed in this section. Is there a motion?
So moved. Second.
Hold on. I just want to share the positions to be discussed in this closed session will be superintendent contract, assistant superintendent services contract, assistant superintendent of HR contract, deputy superintendent business services contract, and executive director of technology contracts.
Any other discussion? All right, call for the vote. Please vote. Motion passes to adjourn to closed session, 5-0 vote. And then just leave it there. Oh, and the time is 6:22.